In response to a recent federal law that aims to stop surprise billing at hospitals, there has been an increase of actions dealing with surprise billing at hospitals. So the federal government took note that a lot of people get bills from hospitals they don't necessarily expect. Because when you go to a hospital, you run into the issue of not only does your insurance cover the hospital itself, but also the person at the hospital, which sometimes they don't, right? So who is within your plan might depend on the individual doctor inside the hospital. And of course, depending on the situation, you may not necessarily be in a position to know or even be conscious of who this person is. Because if you're going to a hospital, maybe it's because there's been a catastrophic emergency. And maybe you're not really in a great position at that particular moment to ask questions like, hey, are you within my plan? You know, or even conscious at the time. So we are concerned about this possibility. So the federal government stepped in, but of course, now the lawsuits have come. Let's learn a little bit more. In a year following the implementation of an arbitration process established under the federal law called the No Surprises Act, 330,000 disputes have been submitted for the arbitration. This figure outpaces predictions from the federal government and complicates implementation. So yeah, the federal government said, all right, we're going to set up a process so people don't get surprise billing. We're going to set up a process in arbitration. How many people want to arbitrate? Apparently everyone is the answer. So we got way, way more of these things than we expected. So great. As background, Congress passed the law which became effective in 2022 to help curb so-called surprise medical bills, balance bill received by a patient in situations which they have no control over who's involved in their care, such as, for example, a hospital where you don't know what doctor is operating on you, possibly because you're unconscious at the time, or what anesthesiologist is involved, or whatever. Frequently, patients incur these bills when they obtain emergency care from a facility which itself is out of network, or non-emergency services at in-network facilities, or possibly from the ambulance ride, or possibly a lot of other things. Our system is somewhat fragmented. So yes, you might get a bill from whomever that you didn't expect. And the ambulance might take you to a non-covered facility because again, you might be unconscious at the time. So that could be a problem. In these situations, the law is designed to forbid the out-of-network provider, whether that's the hospital or the doctor's office or the doctor themselves, from balance billing the patient to collect the difference. So we are basically going to force you to be treated like you're in network in this situation. All right. We are now, as a matter of law, declaring that you're in network deal. Well, of course, the you're in network deal, less popular with the insurance companies, as you would expect, because, well, they're not in network for that it's like we suddenly have this bill from this person. We don't know who this is. And like, we have to pretend that they're our client. So they're not so thrilled about that. To protect the patients, the relative law establishes an alternative dispute resolution, allowing the parties to submit claims to an independent dispute resolution panel to determine this. So we could go to court over it, as we always could, of course. We could have a lawsuit over it. But we also established this dispute resolution process as well to do that. So you can go that way. This dispute resolution process was intended to be streamlined and efficient. We're going to get around some of the problems that courts bring to bear. Of course, also courts themselves are a bit overloaded. So we're going to create a different path that will be faster and better and cleaner. But, this has not gone that well because they've been inundated with submissions since the law became effective. So a lot of people think their bills are a problem. The volume of claims has created a backlog hindering providers' ability to obtain reimbursement for services. In an effort to promote transparency, the Department of Health recently issued a status update on the arbitration process. The report revealed several key findings regarding volume, eligibility, and outcomes of claims. So the law's implementation has been a little bit tenuous, which sometimes these laws, when implemented, are a little bit tenuous. What the Congress or the legislature of your state or whomever thinks will happen and what actually happens sometimes have some different results. The report released by the government indicates overall numbers of claims that have been filed. Since the submission portal first went live April 2022, there have been 330,000 claims. This is 14 times more than the initial estimate. So initially we thought maybe 30,000, and what we got was 330,000. So, well, it turns out our alternative path really popular. People would like to do the alternative path, but we were expecting like 30,000, and we got 330,000. So we weren't really set up for this. So it somewhat slowed our streamlined, efficient process. Yeah. The report indicates that this streamlined, efficient process has rendered determination in favor of one party or another only in a small fraction of the cases. Approximately 42,000 disputes decided as of March. So we thought maybe we'd do 30,000 a year. That was our estimate. We thought 30,000 claims a year. Hey, we actually did 42,000. So we're doing good. We're almost doing 50% more than we thought we could handle. But unfortunately, the 50% more that we thought that we could handle is somewhat dwarfed by the 14 times number of requests. So 50% versus 1,400%, these two numbers are a bit different. Third, these panels have closed more cases than decided. Overall, more than 100,000 claims, more than 4 times anticipated, have been closed. So we thought maybe, there'd be 25,000 that would just basically be dismissed, as it were, because they were improper claims, but we have 100,000 of them. Some claims, of course, were closed following successful negotiations. Other claims were closed due to failure to pay fees. A large number, 40,000, were closed for eligibility reasons. So sometimes it's because they didn't pay us. Sometimes it's because they settled. Sometimes it's because they weren't eligible in the first place. So people have seen this as an avenue to get relief who weren't entitled to relief. But, they thought they were. So, yeah. The parties that are challenged, which often are the hospital, of course, have challenged the eligibility of about a third of the claims, which, you would kind of expect, your motion to dismiss, whatever we call it, but this is an arbitration process. We'll call it something different. But it's the same thing. Motion to dismiss, failure to state a claim. You are not an eligible party. A third of the time. Sounds about right. But apparently that was way more than we expected. I'm not sure why, but it is apparently. Non-issuing parties frequently object that claims are not eligible for arbitration, including lack of timely negotiation, arbitration substitution, or because the claims involve insurance programs outside the scope of the relevant law. So I'm not sure why we expected them not to file a motion to dismiss for failure to state a claim a third of the time. I'm not sure why we thought that number wasn't a realistic number, but apparently we didn't think that would be that many. But that's what we got. In addition to objections lodged by, the doctors or the hospitals, the arbitration panel have an independent duty to confirm claims, which, makes sense. Subject matter jurisdiction by another name, right? It's not a court, but it's the same principle, right? Subject matter jurisdiction, can this body hear this thing? These determinations require the body to engage in what can be a complex analysis, because sometimes, of course, it is, frequently requiring the submission of additional information from the parties. The report finds that these eligibility determinations represent a cause of delay. So we spend a lot of time trying to figure out whether or not you're eligible or not. And that consumes us. So, yeah. Finally, in an effort to help resolve the delay, the status update includes the Department of Health has begun requiring the initiating parties to submit additional information. So we are going to try to solve this problem, at least in part, by requiring the people who are submitting the request to submit more stuff as part of their request. So we want to increase the paperwork burden on their request and make it harder to file the request and maybe discourage people that way. So, okay. The department has also modified the arbitration portal to require the input of additional information. These are among the ongoing technical improvements. So part of the way we're solving this is by requiring the people who want our involvement to give us more information and just make it harder and more difficult. So some people, presumably, who are eligible will just simply be frustrated out of it. So We're trying to solve the problem that way. Let's see if that works. Meanwhile, legal challenges to the entire regulatory scheme itself also continue because, a lot of people maybe don't think that this is a good thing or even a legal thing. The developments have fueled speculation that Congress might step in and pass additional legislation to fix this problem. So, of course, there have been lawsuits over the entire scheme because, of course, there are. We don't really like the arbitration. We don't think it's set up properly. We don't think it's fair. We think their processes are bad, blah, 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 blah. So there's been lots of problems. So maybe Congress will have to come in and try to fix it. And I'm sure they'll fix it in a way that will create no new problems in its wake. I look forward to this new congressional legislation. Thus, that brings us to the end of the discussion over the moment of this federal law, which tried to stop surprise billing, which is a legitimate concern. No one can deny that. You are brought to an emergency room for some treatment. Do you have control over which doctor helps you? Do you have your control over your anesthesiologist? Do you have control over your surgeon? Do you have control over which doctor comes to visit you during rounds? Do you have control over your nurses? Probably not in a lot of situations. And what are you supposed to do? Like figure it out for each one. And it's like, I can't get this treatment right now. We have to spend 2 hours, going through the finer points of the charge schedule to figure out whether or not you're covered or not as I'm bleeding. So, this is a bit of a problem. Congress tried to solve this problem by saying, okay, fine. In these situations, we'll just basically effectively declare that you are in network. Okay, you're in network now. Everyone's in network. That solves the problem, right? Well, not so much, because it appears that 14 times more people have wanted to take advantage of this because, the hospital bills are very expensive. And somehow they didn't see that coming. So there's been controversy. Also, the entire scheme itself, of course, presents legal problems for obvious reasons, because we are trying to set up something in substitution for courts, which, you can do. But, maybe that wasn't set up properly. Maybe it's not being implemented properly. But no problem. Congress is aware of the problem and is going to fix this right up. So I assume we can look forward to a clarifying law any day now, which will solve this and every other problem in our healthcare industry. And that, for the moment, brings us to the end of discussion of this case.